Alright, hello everybody and welcome to this 10th edition of Soundbites. My name is Stephen Reagan and I am the principal privacy consultant and a subject matter expert on privacy and data protection here at Rangu. So I'm going to get right into it, a little introduction on what I will be discussing today. There's a number of topics that I want to explore, and the first being the European Data Protection Board's guidance on the concepts of controller, processor, and joint controller. So I'm going to flesh out some of those definitions, what it means to determine the purposes and means of processing, as well as look at some of those obligations and responsibilities based on the designation of an organization under the GDPR. From there, I will turn to Ireland, another case with the European Data Protection Board and their dispute resolution powers under the GDPR, in particular Article 65, and look at how they've used this dispute resolution mechanism in order to deal with some issues coming out of Ireland, really focusing on the Irish Data Protection Authority. And the Irish DPA is the lead supervisory authority for some of the biggest technology companies in the world, and has been accused of kind of dragging its feet in regulating these organizations. For what reasons, it is unclear, but I will just look at really the Article 65 dispute resolution mechanism that the European Data Protection Board used in order to kind of force the Irish DPA to move a little quicker in some of these areas. From there, I will turn to Max Schrems. It seems that he is going before the Court of Justice of the European Union again with a case against Facebook. Not as drastic as the Schrems 1 and Schrems 2 decisions that invalidated respectfully the Safe Harbor Agreement and then the Privacy Shield. It seems that this case will be about clarifying whether Facebook's reliance on a legal basis, in particular the necessity for performance of a contract, is lawful. This is something that changed from consent to necessity for performance of a contract when the GDPR went into force. And then from there, I might explore a bit about some interesting technical developments that are ongoing, in particular in America, looking at this global privacy control and its implications for privacy. In California, the Attorney General just said in the past few weeks that organizations operating in California have to respect this global privacy control, and that's essentially a plugin on your browser that is equal to going to every website that you visit and clicking on this "Do not sell my data" button, so that it's done automatically, and that's got really interesting implications for privacy and how we effectuate that privacy, in particular in the context of America. At the same time, None of Your Business, the nonprofit affiliated with Max Schrems, is also developing their own product called the Advanced Data Privacy Control to really effectuate some of these mechanisms in Europe under the GDPR. There are divergences in the law, the CCPA and the GDPR. And I will explore a bit about how these technologies will go into force and kind of what they are seeking to do. And then potentially I will talk a bit about the Pegasus spyware investigation and the implications that has for privacy and data protection, just exploring exactly what happened. And some of the consequences that are arising out of that situation. All right, so first I'm going to turn a bit to the European Data Protection Board's guidelines on the concepts of controller, processor, and joint controller. Understanding these concepts and how they apply to your organization is really important because the various concepts or entities have differing obligations under the GDPR and responsibilities that they have to conform with in order to comply with the regulation. So first I'll start with a controller, then I'll look at the definitions of joint controller and then processor, and then look a bit about these data processing addendums or data processing agreements that organizations need to have in place. So a controller determines the purposes and means of the data processing. A controller can take the form of an individual, such as a CEO or CPO, or a group of individuals, but often in practice, the controller is an organization. Now, the key aspects of a controller is really determining the purposes and means of the processing. This is the critical decision making over key elements of data processing that answers these questions of why the data is being processed and how it's being processed. So the European Data Protection Board and its guidelines cites unnamed dictionaries to define purpose, again, as an anticipated outcome that is intended or that guides your planned actions, and means is how a result is obtained. Now, the controller must decide both the purposes and means. It cannot leave these important critical aspects of determination for the processor. So this does not mean that the processor does not have leeway in making certain decisions, but the European Data Protection Board delineates in particular essential versus non-essential means. So essential means answers these questions like what data is being processed, how long will that data be processed for, and who shall have access to the data. So these are just some of the examples that the European Data Protection Board cites, but that determination of these critical means is really looking at how this result, how this goal of the processing activities will be achieved. Now, some of the non-essential means that is left for the processor to determine, for example, is what software or what hardware is being used to process the data. But those critical questions, why the data is being processed, how the data is being processed, this is really left to the controller to decide. And if we think about what processing means under the GDPR, that Article 4 definition, processing is really anything you can think of to do with the data, from storing it, structuring it, analyzing it, transferring it. All those critical aspects of data use must be determined by the controller. This is really important for those organizations designated as a controller, because the controller is the main organization responsible for compliance with the GDPR. If you are outsourcing your processing activities, that doesn't mean you are able to outsource compliance with the GDPR. In particular, those requirements under Articles 24 and 25, ensuring that technical and organizational measures are in place, and using processors that will provide sufficient guarantees to implement their own technical and organizational measures. Along with that, the controller must keep records of processing activities, as the processor must as well, and where that processing may present a high risk to the rights and freedoms of data subjects, conduct a data protection impact assessment. It's also really important for controllers to have in place means for facilitating data subject rights and data subject requests. Now, you can leave it to the processor to respond to those DSRs, or you can have the processor then notify the controller about certain data subject requests, and then the controller facilitates them. Now, the processor, if there is a breach with or an incident with the data of the controller, the processor's obligation is then to notify the controller, who then has the obligation of notifying the data protection authority within 72 hours, and again, where it presents a high risk to the rights and freedoms of the data subjects, then to notify the data subjects as well. So again, critical aspects for determining who is the controller, really looking at who is determining those purposes and means of the data processing. This analysis for a single controller also tracks on to the designations of joint controllers. But in the case of joint controllers, it's where two or more organizations jointly determine those purposes and means. Then, if they do that, they are joint controllers. Now, it's kind of an interesting analysis for joint controllers. Well, interesting is a matter of opinion, but that's neither here nor there. Joint participation in these determinations of the purposes and the means can arise from a common decision where the two controllers say, okay, this is answering that why the data is being processed, or they can be converging decisions. So case law from the Court of Justice of the European Union suggests that decisions converge if they complement each other and are necessary for the processing to take place. Even when the purposes are not the same, joint controllership may exist if the purposes are closely linked. So looking at what it might mean to jointly determine the purpose, again, common decision, converging decision. These are key distinctions that nonetheless can result in joint controllers. So for example, in this case of Fashion ID, the CJEU clarified that a website operator and the provider of a social plugin, in this case the Facebook like button, on another website, was sufficient to create the situation of joint controllers, as the operations of both organizations were in the economic interest of both parties. So converging purpose. The website operator was able to increase the visibility of its products while Facebook acquired more data on browsing habits. So jointly determined purpose. Now, what is a jointly determined means? Joint controllership requires two or more entities exert influence over the means of the processing. Again, it may be the case that one organization provides the means of the processing and makes it available to another organization. So in the European Data Protection Board's guidance, again, Facebook was the example, and what they were demonstrating, what the court argued, or the outcome of the court's decision, more accurately stated, is that a Facebook administrator, so somebody administering a group, a Facebook group, using data and processing information provided by Facebook, was sufficient to create a jointly determined means. So it wasn't that the administrator was processing the data, they were getting this information from Facebook, and they were using that information, and the Court of Justice said this was sufficient to create the situation of jointly determined means. So, again, we have this definition of purpose and means. The controller determines this. Joint purpose, jointly determined means, has the situation of creating a joint controllership. So there are certain delineations of responsibilities for joint controllers that they must be aware of. Excuse me. Again, you cannot outsource compliance with the GDPR. Controllers are the main entities responsible for that compliance. The joint controllers then, in this case, must determine their respective responsibilities. For example, to comply with data subjects exercising their rights, who's going to be responsible for responding to those data subject requests, data subject rights, and as well as a responsibility to provide certain information, the right to inform the data, the right to be informed for the data subject under Articles 13 and 14. So the distribution of responsibilities should also cover the legal basis for processing, with each joint controller ensuring that they have one. So there are a lot of things then for joint controllers, of course, to think about as well. They need to collect ROPAs, they need to conduct DPIAs. But, we had this situation, joint controller, joint purpose, jointly determined means. Joint controllership arises. Now, turning to the processor. Organizations that process data on behalf of a controller is a processor. That can take the form of subsidiaries of an organization. So say you have a big tech company headquartered in Ireland. They have subsidiaries throughout Europe who process data on behalf of that main establishment in Ireland. These can also take the role of a processor. And there are two basic criteria for a processor. Again, it exists separately from the controller, and processes personal data on behalf of the controller. A processor processes data in accordance with the controller's instructions. The controller determines those purposes and means, and the processor processes the data, tries to achieve that how in accordance with the controller's decisions. That is governed generally, again, by a data processing addendum that may still leave, again, some discretion for the processor to determine certain aspects of the processing, but in essence, the processor processes that data in accordance with the controller's instructions. So at the end of what happens when the processing period is over? Well, I guess before I get to that, let me say just very quickly that the processor must also keep records of processing activities. Again, in the case of an incident or a data breach, processors have the obligation of notifying the controller, who then notifies the supervisory authority. There should be in this data processing addendum certain controls or processes for responding again to these data subject rights, data subject requests, managing those Article 13 and Article 14 requirements, again, the right to be informed. And then at the end of that contract, the processor is often obligated to delete and return all of the personal data to the controller. The processor must also be able to demonstrate compliance with the GDPR to the controller and those obligations laid out in particular for the processor under Article 28. So that's a bit of a summary of over some of those concepts of the controller, joint controller, and processor that the European Data Protection Board outlined in its recent guidance. From there, I'm going to turn to the dispute resolution mechanism under Article 65. Alright, so turning to the next topic, I'm going to briefly discuss the European Data Protection Board's adoption of a dispute resolution decision on the basis of Article 65. So this decision sought to resolve a lack of consensus on certain aspects of a draft decision regarding WhatsApp issued by the Irish Data Protection Authority. The Irish Data Protection Authority is the lead supervisor for many of the largest technology companies in the world. The decision issued by the Irish DPA followed an inquiry from WhatsApp regarding its own transparency obligations. On December 24th, 2020, the Irish Data Protection Authority shared the draft decision in accordance with Article 60, Section 3, saying which says the lead supervisory authority shall, without delay, communicate the relevant information on the matter to the other supervisory authorities concerned. It shall, without delay, submit a draft decision to the other supervisory authorities concerned for their opinion and take account of their views. So the other supervisory authorities issued objections pursuant to Article 60, Section 4, where if any of the other authorities concerned within a period of 4 weeks after having been consulted express a relevant and reasoned objection to the draft decision, the lead supervisory authority shall, if it does not follow the relevant and reasoned objections or is of the opinion that the objection is not relevant or reasoned, submit the matter to the consistency mechanism referred to in Article 63. The Irish Data Protection Authority was unable to reach a consensus and indicated this to the European Data Protection Board. Accordingly, the objections were also referred to the EDPB for determination pursuant to Article 65(1)(a), initiating the dispute resolution mechanism. Then the European Data Protection Board adopted its own binding decision. So let me go in a bit detail on Article 65, which provides that in order to ensure the correct and consistent application of the General Data Protection Regulation throughout Europe, the EDPB can adopt binding decisions in certain cases, including where a supervisory authority concerned has raised a relevant and reasoned objection to a draft decision of the lead supervisory authority. So the outcome is that the Irish Supervisory Authority shall now adopt its final decision addressed to the controller, WhatsApp, on the basis of the EDPB decision without undue delay and at least 1 month after the European Data Protection Board has notified its decision. The European Data Protection Board will publish its decision on its website after the Irish Supervisory Authority has notified their national decision to the controller. So really what was in play was that the Irish Data Protection Authority proposed a penalty against WhatsApp in the range of 30 to 50 million euros. This would have made it one of the largest fines under the GDPR. What had been the largest fine was 50 million euros levied by CNIL in France against Google. That has been just blown out of the water by this recent fine from the Luxembourg Data Protection Authority against Amazon for somewhere in the region of 800 million euros. Nonetheless, this is still a sizable penalty, but evidently it was not large enough as other European supervisory authorities raised objections to this decision. Again, Ireland disputed these objections, but the European Data Protection Board found the objections to be reasonable. The Irish regulator now has 1 month to implement a final decision. Among the issues with Ireland's draft, again, was this appropriateness of the envisaged corrective measures. Again, that's fine. So, we will see how it plays out in due time, at least within the month. But it really just highlighting this dispute resolution mechanism for the European Data Protection Board under Article 65. Some of these articles don't get all the fancy attraction as Article 30 ROPA or the data breach response, Article 33 and 34, or the DPIA and Article 35. Look, we have some interesting dispute resolution mechanisms under Article 65 when there is not convergence between the supervisory authorities, which there sometimes isn't. Some supervisory authorities have more resources to bring enforcement actions against organizations, and then others that have again, for Ireland's Data Protection Authority, the largest tech companies in the world are headquartered for Europe in Ireland, which puts a lot of the enforcement pressure on the Irish Data Protection Authority. So at the same time there are these competing interests. Of course, the Data Protection Authority has the duty to implement the General Data Protection Regulation, ensure compliance with it. At the same time, Ireland wants to position itself as a welcoming place, welcoming environment for these organizations, which really bolster the local economy. So there are some competing interests, the regulations versus economic interests, and so we are seeing how that is playing out, in particular here with the European Data Protection Board seeking to ensure a uniform application of the GDPR throughout Europe, and looking at some of these dispute resolution mechanisms between the different supervisory authorities under Article 60, Section 3 and Section 4, as well as this binding decision by the European Data Protection Board. So with that, I'm going to turn to a recent Austrian Supreme Court case. Mr. Schrems, he is a resident of Austria, brought a case against Facebook. Some of those questions that were pertinent in the before the Austrian Supreme Court are now making their way to the Court of Justice of the European Union. And it's really the Austrian Supreme Court requested the CJEU clarify whether Facebook's reliance on the legal basis Article 6.1b, necessity for performance of a contract, is lawful. So beyond that question, the Austrian Supreme Court referred 3 other questions to the CJEU. Those questions being whether Facebook's use of data on Facebook.com and from other sources, such as websites that use this plugin, the Facebook like button, for any purpose, is compatible with the GDPR's data minimization principle under Article 5.1c, and whether Article 9, Section 1 of the GDPR applies to the processing of data which permits the targeted filtering of special categories of personal data, such as political opinion or sexual orientation, for advertising purposes, even though the controller does not differentiate between this data. So, the real predominant question, again, is on Facebook's reliance on the legal basis of a necessity for performance of a contract. Prior to the GDPR going into place, the processing relied on consent. Now this has shifted. Once the GDPR came into effect, the legal basis shifted to necessity for performance of a contract. Contract being that data subjects, the users of Facebook, want to see certain advertisements. And so on the basis of that, Facebook has this contractual obligation then to collect this data and use it to show their users relevant advertisements. This is the contractual provisions that you evidently sign up for when you sign up for a Facebook account in Europe. So we will see how the Court of Justice resolves some of these questions. This is not the first time that Mr. Schrems has been before the CJEU bringing a case against Facebook. We have those seminal cases, Schrems 1 invalidating the Safe Harbor Agreement, Schrems 2 invalidating the Privacy Shield. Those were transfer mechanisms of data from Europe to the United States. Now we have kind of less prominent questions. I guess the consequences might be less prominent, but the questions are no less important or relevant, again, as we try to iron out exactly what the GDPR means and how it's implemented. So with that, I will turn to looking at this global privacy control and what it means for effectuating privacy and data protection in America, potentially also in Europe. All right, so looking at this global privacy control, this is something really interesting that just happened in California, where the Attorney General said that organizations falling under the CCPA, the California Consumer Privacy Act, California Consumer Protection Act, must comply with the global privacy control. So what this is like a browser extension or a plugin that is already being recognized by some search engines, Mozilla, DuckDuckGo, some of the major publishers, New York Times, recognize this global privacy control. So what is it? The global privacy control is, essentially a browser plugin that would find all of these do not sell or share my data buttons that organizations are obligated to have on their website under the CCPA, and it would in effect press this button. In effectuating our privacy and data protection, it can be really difficult, especially when the onus is on the individual to take some affirmative action to protect their own privacy and data protection. So in some sense, the default setting is not to protect these rights. And this highlights a really big difference between the GDPR, the Privacy and Data Protection regulation in Europe versus in America. And it really highlights this opt-out versus opt-in debate. In Europe, organizations, businesses must get the opt-in of the data subject in order to in order to process the individual's data. So the incentives are for the business to provide certain information, give certain rights to the individual, but the business and organization has to take that affirmative step to get that buy-in from the data subject. The default in America is different. It is opt-out. So businesses and organizations can collect the data from the outset. The impetus is for then the individual to take affirmative action to protect their privacy, to tell organizations, okay, you cannot do certain things with my data. This can be really difficult. A lot of it's not uniform how those processes take place in California, where the button is on a website, or how to effectuate your data subject rights. Even here in Europe, this can be a challenging task for individuals. So what this global privacy control does is really try to effectuate these principles of privacy and data protection and make it easier for the individual to do this. Again, this global privacy control browser extension that would be like searching for this do not sell or share data button on all of the websites you visit, as a resident of California. So it's a really welcome decision, kind of innovation, and a technological solution to providing privacy and data protection. So the Global Privacy Control is a plugin that's in America, facilitating this do not sell provision of the CCPA. But none of your business, the nonprofit affiliated with Max Schrems, who I just talked about, is also developing their own advanced data privacy control that would do something similar. Now, I don't have all the details on it, but it would be, for example, like withdraw your consent for processing for every website that you visit that processes data on the basis of consent. So a similar idea, and see these technical solutions trying to play out across America and the EU. Now I'm coming to the end of this soundbite, and I promised that I would discuss this Pegasus spyware investigation. And this was, there was revelations on 18th July from an investigation by Amnesty International and Forbidden Stories that revealed that more than 180 journalists in 21 countries, including India, Mexico, Saudi Arabia, France, Morocco, Hungary, and Azerbaijan, were targeted by this organization called the NSO Group. And what the NSO Group has put out is a technology, a malware called Pegasus that infects iPhones and Android devices to enable operators of the tool to do, draconian things on your cell phone. Really, like when you think about all the conspiracy theories about what can be done with your cell phone, accessing the messages, turning on the camera, turning on the microphone, or evidently this malware was able to do that. And this was a product put out by this NSO Group, a major Israeli cyber surveillance company that really came under heightened scrutiny. And some of these major human rights organizations like Amnesty International have published open letters calling on the limitations of this type of technology, looking at something for an international mechanism to facilitate the protection of these human rights, privacy and data protection globally. Of course, it's a really big challenge. We don't really have, we have an international body of law for human rights, but we are looking at, these organizations are advocating for a similar principle to be applied to privacy and data protection, relying on those terms like necessity and proportionality. But this is definitely a really interesting issue to watch and to see how it will play out. The tool was targeted and sold as a way to fight crime, protect national security, but unfortunately, it had been applied to journalists and lawyers and activists in a really concerning way. And so, definitely something to keep an eye on. I won't go into too much detail on the Pegasus project, but there are a number of resources with which you can search for and read up more on it. Again, some of those major organizations include Amnesty International. The Guardian has published some articles on the topic. There are also ways to check to see if your own phone or device is infected with the Pegasus software. And so I'll just end with a statement by the UN human rights officials who published a statement reminding state governments that surveillance measures can only be justified in narrowly defined circumstances when necessity and when they are necessary and proportional to a legitimate goal. And with that, thank you for tuning in to this 10th edition of Soundbites, and I really look forward to speaking with you or talking to you in this medium again soon. Bye now.